Okay, so thank you everybody for joining us today. This is a webinar that is focusing on the new rent laws that were passed back in June. So we're going to learn today about how tenants are protected and empowered by these new laws that were passed. Joining us today is Andrea Shapiro, who is the program manager and member organizer at Metropolitan Council on Housing. So I thank her for joining us today. Okay, so a quick introduction about PSS. PSS is a unique and cutting edge agency that has a wide range of services, and our primary mission is to build capacity and strengthen communities of New Yorkers. PSS Life University offers an array of educational programs at many of our centers and other locations that help communities stay engaged and connected. Circle of Care is another program that PSS offers. It is primarily a support system for caregivers of people who have Alzheimer's or dementia or some other condition that incapacitates them. It's a wonderful program that is serving a large number of communities in the city. And then another program that we have is the Grandparent Family Apartments in the Bronx. Also, our Coming of Age program is something that focuses on helping people who are 50 and over to stay engaged and connected and find purpose. We have 10 centers across the city, and we welcome volunteers to help us deliver these services. Okay, so with that, I'm going to turn it over to Andrea.
Hi, everyone. How are you doing today? My name is Andrea Shapiro. I am the program manager at the Metropolitan Council on Housing. The Met Council on Housing is New York's oldest tenants union. We've been fighting neglectful landlords and politicians since 1959, which makes this our 60th year. And we believe that all people deserve decent, stable, and affordable homes. And we believe we'll get there by organizing tenants around this issue. We feel that the people who are able to best help each other are tenants, and that tenant rights information isn't something just for lawyers, that it's actually something that all tenants can learn about, understand, and then enact. And before I begin, don't know if this works in this technology, but can some of you maybe type in some of the housing issues you've dealt with, or?
Yes, thank you, Andrea. I wanted to encourage people to use the Q&A function at the top.
Ooh.
They could write down some questions as you are presenting. That was something that I forgot to mention. And also, I just wanted to let everybody know that this is being recorded, and that it's something that will be able to be used in the future. I apologize for that interruption. Thank you, Andrea.
No problem. Yeah, so if people want to write down some questions they have to get us started, that way I can make sure I cover sort of the most important things. And as was said, this year was a very big year for tenants' rights. The rent laws, which are the laws that govern rent stabilization and rent control, up until now expired every few years. And it was sort of our chance to really make big changes in New York. And this happened on June 15th of this year. And it paired up with some really other big changes in the state. The makeup of the state Senate changed dramatically, actually a year ago today. Completely changed from Republican-controlled state Senate to Democrat-controlled. It had been Republican-controlled in various ways for almost 40 years. And it was really hard to get pro-tenant legislation passed. And so every time the rent laws had expired, there had been really big loopholes that had been put in. And we were we looked like we would actually lose the program at some point. And with the change of the makeup in the state Senate, the Democratic controlled assembly, we were able to make really big changes this year, but it didn't come without a big fight. Let me see if I can. So I'm going to share. And so we spent the last year campaigning to figure out how we can pass the rent laws, to going up to Albany nearly every Tuesday, meeting with our elected officials, particularly having tenants meet with their elected officials, so that we were able to make the change that we needed. So the Met Council runs a tenants' rights hotline. It is open and free to the public. Any tenant is able to call us up and get their tenants' rights information. It's 3 days a week. Monday and Wednesday, 1:30 to 8, and Friday, 1:30 to 5 p.m. We also have 2 clinics, one uptown in Inwood at 5030 Broadway, where it's very similar to our hotline. We are able to answer any question that tenants have. It doesn't matter what type of housing, how old they are, their income, they're a tenant, we're able to answer their question. And then we have one downtown in the clinic, in the village that we run. So to get us started, sort of an overview of tenants' rights, just an explanation of some terms. Tenant is anyone who's lived in a place for 30 days or more. Co-tenant is when you're both on the lease. A roommate is when the leaseholder is in the apartment, and a subleaser is when the tenant does not live in the unit. And so you'll see in the corner, the slide helps explain what the different rights pertain to. We'll talk about some rights that are pertain to everyone, and then we'll talk a little bit about rent stabilization, NYCHA, and Section 8, and rent control. So first, this year, there are some big changes to just simply how you get an apartment. Now, security deposits are limited to 1 month for all tenants, and you should be able to get your security deposit back within 14 days of giving up the apartment. The landlord needs to give you a list of why they're withholding the money, as well as background checks are now limited to $20, or you can provide your own. And this is really important for Section 8 tenants. So if somebody has a voucher and is trying to find a new apartment, this used to be a big problem because Section 8 does not cover all the things that get you into the apartment. And so now getting into the apartment is a little cheaper at least. And this is something we're seeing landlords violating left and right, partly because it's a little bit hard to enforce. It's really important if you see someone asking for more than $20 for a background check or more than 1 month security deposit, that you let the Attorney General's office know. It's also easier to break a lease. And for seniors, someone going into long-term care, someone who needs to move in with a family member, they've always been able to break their lease. And now anyone is able to break their lease, and the landlord now has the duty to mitigate, which means that they are responsible for finding and trying to find a new tenant. They have to show a good faith effort that they've actually done it, and the proof is on them that they've looked for a new tenant. New York City has very strong anti-discrimination laws. The Human Rights Commission is one of the more robust commissions in New York. The problem is that if discrimination is happening, the tenant doesn't get the apartment, but at least the landlord will get hefty fines. And landlords are not able to discriminate because someone's been taken to court because of how they get their income, so what job they have, or if they have a voucher, if they have children, their age, immigration status, sexual orientation, gender, race, and religion. The best way to be able to prove this is if the landlord writes it down. But if you suspect that discrimination was part of why you or your client didn't get an apartment, please call 311 and talk to the Human Rights Commission, because if we can stop bad landlords from doing it, we're able to open up a lot of housing in New York. So your rights as a tenant, the first one is that no one can be locked out or the locks changed, stuff moved out of their apartment without a court order. Landlords love to tell tenants, you're going to be evicted. It's a very broad term that they're using. Tenants do not need to move until a court orders them to move. It's really important because a lot of people have the ability to stay in their apartment. Landlords like to lie about evictions. And so until there's actually a marshal's notice, no tenant is actually being evicted. If this does happen, you can call 911. Actually, it's on the patrolman's guide. They're able to help the tenant get back into the apartment, or going to housing court, and there's a special window for illegal lockouts. All tenants have the right to something called the warrant of habitability, which means that they have a right to repairs. Landlords cannot have the tenant waive this right. It doesn't matter if it's a private house or a 1,000-person building. All tenants have the same rights around repairs for clean common areas, heat and hot water, extermination, particularly for seniors. This is important. People who receive home health, a lot of home health aides coming in and out of their apartments, are more likely to get bed bugs. In fact, anyone who has a lot of people coming in and out of their apartment are just more likely to get bed bugs in New York. It's part of New York. We are the right environment. We live close enough. We're warm enough. Landlords have to exterminate bed bugs. It's not the tenant's fault. The tenant cannot be evicted for bed bugs. A lot of people feel a lot of embarrassment around insects and rodents and bed bugs, but it's just the nature of living in an environment that's warm. And so it's the landlord's responsibility. They have to continue to get rid of it until the problem is solved. Landlords are also responsible for things like getting rid of the garbage, lead poisoning protection, and appliances. And when we say heat and hot water, all tenants are supposed to have hot water all year round that can reach at least 120 degrees. And heat season is a particular time of year in New York. It goes from October 1st to May 31st. During the day, if it's less than 55 degrees outside, your apartment should be at least 68 degrees. And at night, it should be a minimum of 62, no matter what the temperature is. I know for a lot of seniors, this is not warm enough. It's really important that if you're not experiencing enough heat, that you report it as soon as possible. A lot of people wait a long time to report heat problems. So we see a spike in people reporting problems about heat in April. And the problem is that it might take a little bit of time for the city to inspect. And by the time anything can really be done, heat season's over and you've gone the winter without any heat. And so if someone's coming in and saying that they don't have enough heat, it's important that we start the process of reporting it as soon as possible so that they can get heat during the winter. And so how to get repairs. First, you need to ask. We always recommend don't ask alone. Bring a friend, bring a neighbor. You don't need a formal tenants association. Just having someone with you makes it easier. Second, put it in writing. And we always recommend sending things return receipt so that you get that green slip in the mail saying that the landlord received it. Then tenants need to call 311 to get an inspector to look at the problem. And fourth, all tenants can bring their landlord to housing court. This is true for both tenants in private buildings as well as public buildings, but we all know that NYCHA doesn't work as well as it doesn't do repairs. It's hard to get repairs, so organizing is really the best way to get a repair in NYCHA. The city responds when they're embarrassed, when there's a lot of people asking for it. So it's one of the best ways to get a repair in NYCHA. Does anyone have questions about repairs or the warrant of habitability? All right.
I think, yeah, let's save the questions for the end.
Okay.
And also because I think their audio might not be enabled right now.
Okay. Another important thing is that all tenants have the right for roommates. This means first that your family is able to share the apartment with you, so dependent children, you can have as many as you want until you reach overcrowding. And then tenants can have a roommate. You cannot be evicted because you have a roommate living with you. In a rent stabilized apartment, you can't charge the roommate more than half of the rent. And landlords like to tell people you're not allowed to have a roommate. I need to do a background check on your roommate. I get to decide who lives with you. That's not true. You get to decide who your roommate is, and you just need to tell the landlord their name. If someone's living in a Section 8 building or NYCHA, they need to check more with the program or in a supportive housing environment. Particularly senior complexes, generally the roommate needs to be over the age of 65. Tenants also have the ability to sublease. That means they can leave the apartment, go somewhere else outside of New York, and come back to it. So this particularly means for seniors often, if they're an immigrant and they want to go home for several months, they can sublease their apartment in the meantime. They want to go live with a child somewhere else for a year or so, they're able to sublease their apartment to someone else, and then they come back and go back home to their apartment. The subleasing process is basically you need to inform your landlord, and your landlord cannot unreasonably refuse. They are able to subject the subleaser to any background checks that they would for any other tenant. And then an important new rule that was passed this year was that your rent is not late if you've paid it within 5 days of the due date. You can't be charged a late fee. You can't be threatened with housing court for being 5 days late. You can be charged a late fee after that. It needs to be in the lease and cannot be more than 5% of the rent or $50, whichever is less. Some leases will say things like, you'll be charged $100 a day. That can no longer be the case. It's also important to know that if someone's getting their income through a public program and that doesn't allow them to pay on the day their rent's due, so if they're paying with their social security check, they can't pay it by the 5th, they can arrange another date to pay their rent. They have that right. It's important. Landlords are entitled to a copy of your key. It's their property, so they have the right to have a copy of the key for it. Landlords are not allowed to enter the property without your permission, though, unless there's an emergency. You are entitled to at least 2 sets of keys, so you can have an extra set of keys. If you lose it, you want to leave them somewhere. Also, if you have home health aides coming into a building, or babysitters, dog walkers, family members who are watching children, or seniors, they're entitled to a copy of the key. And anyone who lives in the apartment that's over the age of 14 is automatically entitled to a set of keys. We are now seeing more and more keys that are electronic, so a key card, a fob. These are often done to try and figure out if a tenant's truly living in the apartment and tracking tenants, but landlords are able to do that, unfortunately. When it comes to immigration, landlords are not allowed to ask about immigration status. They cannot deny renting to someone because of their immigration status. It's also illegal for them to threaten to deport a tenant or report a tenant to ICE. And as of last week, Immigration status does not prevent you from entering for the lottery apartments. And what that means is that you no longer need to provide a social security number or a tax ID number, but you do need to prove your income. And then something that surprises a lot of people is that families of mixed status are able to live in a Section 8 building or in a NYCHA complex. However, their rent is significantly higher because the person who is undocumented does not get the subsidy that the citizen child or a family member has. And there's lots of rights that we have around evictions in New York City, but it's important to know a lot of people get brought to housing court and a lot of people get evicted in New York. Most housing court cases are started by landlords. Most landlords have attorneys, most tenants do not. However, seniors have the ability to get the court to assign a lawyer to them. This means that if they wouldn't otherwise qualify for a free lawyer or having problems, they are able to get the court to ask one of the legal service groups to be their lawyer. This is incredibly important because while people can do housing court on their own, it is a difficult process. The number one way that people become homeless in New York is through evictions. Anyone can be evicted in New York. Seniors are not exempt. People with disabilities, children are not exempt. So it's important as soon as someone starts getting notices that they're going to be evicted, that it's taken very seriously. It's also important that people do not talk to their landlord's lawyers. Most cases are resolved through something called a stipulation, which means in the hallway of housing court, people sign a paper. Most tenants end up signing away their rights. It's important that you do not talk to anyone in housing court until you speak to the court attorney who is able to mitigate what the landlord's saying and inform you of your rights. We do have something called right to counsel in New York City when it comes to housing court. This means that if someone is below 200% of the poverty line and actively being evicted, they have the right to an attorney in housing court. Right now, it's only in specific zip codes. You can look at the Right to Counsel's website, and they have the zip codes listed when you're working with a tenant and trying to figure out if they qualify. If they qualify, when they show up in housing court, an attorney will be walking around with a list of names, looking for them. So there's two types of evictions, and it's really important if someone comes to you saying they're being evicted to know which type of eviction it is, because they will be resolved in very different ways. A non-payment case means that they are being asked for the rent. Once the rent is paid, the case ends. A landlord cannot then say, I don't want to accept the rent, I want you out. The case is only for rent. It's not for late fees, it's not for air conditioning fees, it's not for legal fees, only for rent. And if someone's behind on rent, but able to pay going forward, they're able to apply for a one-shot deal. These can happen more than once. So it's really important if you have a tenant who is behind on rent, they're going to get an annuity, their pension's going to kick in soon, they're waiting for Social Security to start, and once they get that, they can start paying their rent, or they have a family member who can start paying for them or help them out. They can qualify for a one-shot deal and deal with the back rent. People really should focus on their current rent because the city really is able to help them with that back rent they owe. Holdover evictions means the landlord wants you out. You've either overstayed your lease or you violated a term of your lease. So in a non-payment case, the defense can't be, I can't pay. You can say that you're being overcharged, that you're withholding because of conditions in the apartment, which we do not recommend unless you can afford a lawyer or know you will get one through right to counsel. The rent demand needs to be given in writing now, and it needs to be 14 days notice. So you have 5 days before you get a late fee and 14 days before you get a notice in the mail saying that you owe rent. landlords can no longer just tell a tenant, this is your notice, 14 days that you haven't paid rent. They used to be able to do that. They now need to give it in writing. So some other protections that tenants have when it comes to an eviction is, again, a non-payment case is limited to rent only. They're able to get an adjournment for 14 days. This is true for both landlords and tenants can ask for this adjournment. This gives people the time to find a lawyer. So if you have a tenant who doesn't have a lawyer, you're having problems finding them one, go into court, ask for an adjournment. They will get 14 days, which is hopefully enough time to help the tenant get a lawyer. Tenants also have the court papers need to be given within 10 to 17 days before the court, and all breaches of leases can be cured within 30 days, which means that if someone's being accused of clutter, which is really common for seniors, they have 30 days to fix the problem. Also, if they're being accused of being a nuisance, so being very loud, their apartment smells, they're bothering other tenants, they have 30 days to show that they've fixed the problem. It's also really important that a marshal's notice is now 14 days notice. So that means that you have 2 weeks to help a tenant find a new apartment. It used to be 3 days. 2 weeks is not a lot of time to find an apartment, but it does give someone a fighting chance. Also, courts may now issue a stay of an eviction for up to a year. That means that an eviction can be put on hold for an entire year if there's health considerations, a child's in school, other problems on life circumstances, or quality of life issues, which would include a senior center that they go to. And so it's really important that we're asking for this extension for people. If someone's getting evicted, they've lost their court case, they can still stay in their apartment. So it's particularly good for someone who's receiving medical treatment, they've been going to the same senior center for a long time, going to the same doctors, they're caring for a grandchild who's in school in a certain neighborhood, that we can ask for this extension. Particularly unregulated tenants used to have a problem when they asked for a repair. They then would wouldn't get a new lease, or they get a high rent increase. Now, if you ask for a repair and your landlord refuses to do it, either from the government or from your landlord within the last year, you're able to use that as a defense in court to get a new lease up to a year. So we've talked about some types of housing already. So rent stabilization, rent control are very similar programs. You have the right to repairs in your apartment, right to remain in the apartment, and a child or grandchild can take over the apartment. The difference between rent control and rent stabilization, one of the main differences is not having a lease. Rent control tenants do not have a lease. Rent stabilized tenants do. Most rent control tenants are much older and have been in their apartment since before 1971. Unregulated tenants, they have the rights to the repairs. They do not have rights to stay in their apartment or limited rent increases. So what is rent stabilization? Rent stabilization is when a building has 6 or more units and built before 1974 and has not been deregulated prior to June of this year. It used to be when rents reached a certain level and were vacant in a rent stabilized apartment became deregulated. We lost about 300,000 units that way. Apartments may also be regulated because of a tax abatement. So it's really important to do some research if you believe an apartment may be regulated. There's something called a rent history. Landlords are required to report how much a rent is for a rent stabilized apartment. And you can get this by calling the agency in charge, DHCR. And it's mailed to the tenant. It's a pretty plain envelope. It's not very exciting. The landlord does not know that you've received your rent history. As of June 14th, an apartment cannot be deregulated, but apartments that were unregulated were deregulated, were not re-regulated. An apartment rent cannot be raised on an apartment just because the tenant left. Rents are decided by the Rent Guidelines Board for Rent Stabilized Apartment. This is a group appointed by the mayor. It's a really exciting time. Tenants are able to say why they shouldn't get rent increases, what's happening in the city, and actually they've been under de Blasio pretty good. The vote happens in June, and the rent increases take effect starting October 1st. This year's Rent Guidelines Board for 1-year leases is 1.5%, and for 2-year leases is 2.5%. Each apartment in a rent stabilized building has its own legal rent. It has nothing to do with what other apartments in the building cost, which is why it's so important to get the rent history to know what the legal rent is. If a tenant's been being overcharged, they're able to get a lot of money back from their landlord. Landlords are also able to increase the rent by doing work inside of the apartment. This generally happens on vacancy, but it sometimes happens, particularly with seniors, when they get a new appliance. They'll sign paperwork saying that they'll accept a rent increase. They should not do this. The individual apartment increases have now been significantly limited to a total of $15,000 over 3 years, and will theoretically come off the rent after 30 years. We don't know how this is going to work. But hopefully by the time we reach the 30-year mark, we'll figure it out. As I said, if someone's being overcharged, they can get triple damages for 6 years. So it's really important that we're getting rent histories from our clients. We're looking them over and talking with lawyers, talking with other community groups that can look them over, because people can get a lot of money back if they've been overpaying, and their rent can be lowered. There's multiple ways of doing this, by filing with the state, by using it as a defense in housing court, or doing a proactive case. A lot of people used to have something called preferential rent, particularly in the Bronx and Brooklyn. This means that they pay a lower rent than the maximum rent the landlord can collect. It should say it on every lease. This has been a big change in the law. Rents can now only go up by the Rent Guidelines Board or other lawful increases. It cannot go just up to the legal rent as long as that tenant is living in the apartment. This is true for anyone whose leases starts after June 14th. So they may have already signed a lease. Just because they signed it before June 14th does not make it a legal increase. They should ask for a new lease. Also, seniors with preferential rent are now eligible for SCRIE and DRE at their preferential rate. So if you've had someone who's been denied SCRIE because of preferential rent, they are now eligible and should apply immediately. A rent stabilized lease should contain the same terms as the previous lease. Often there are new riders that appear. Tenants do not need to sign any new rider. It's important. Tenants get very anxious over this. They don't need to sign any of the riders. Nothing can be changed from the original lease. If a tenant does not get a new lease, they should not panic. It's actually more beneficial to them not to have a lease. They get to pay the old rent. They actually, some of the ways that you can be evicted, landlords can't do because they've messed up on not sending a new lease. There are forms that you can file with the state. It does not affect someone's eligibility for SCRIE and DRE. The old lease stays in effect. So if people don't have a lease, they should not panic. People get very anxious about it. Rent stabilized tenants can be evicted for not paying their rent, for violating terms of their lease, so illegally subletting, not going through the process with their landlord, not living in the apartment for more than half the year, being a nuisance, and for other limited reasons. Rent control tenants, since you work with seniors, I'll go into this a little bit. It's very rare. It's only about 10,000 apartments. The building had to have been built before 1947 and lived in the apartment. Person lived in the apartment or a family member took over since 1971. They do not have leases. The rent increases used to be really complicated for rent stabilized tenants. They were very high. We believe the rent increase will now for them will be no more than 0.9% thanks to the changes in the law. They also do not need to pay fuel and labor pass-alongs. If you have someone who is paying for fuel and labor pass-alongs, and it will say it in the documents they get from the state and on their rent bill, they should just stop paying it. So seniors and people with disabilities in New York are eligible for something called SCRIE and DRE. This is Senior Citizens Rent Increase Exemption or Disability Rent Increase Exemption. This means that the rent is frozen at its current rate. It will not lower it. The person needs to be in a regulated apartment. For a senior over the age of 62, for somebody with disability, usually receiving SSDI, their income is $50,000 or below, and they pay at least a third of their income in rent. This is really important. They cannot get SCRIE if they do not pay at least a third of their income in rent. People are still rent burdened when they pay less than this in rent, but unfortunately it's only frozen once they become rent burdened. The program is very easy to apply for. It's a simple form that's sent over, but also city council members are really able to help with this. They do this all the time. When a tenant leaves the apartment, a family member is able to take over. So this is really important. Family members are not able to be added to the lease until the person who's on the lease leaves the apartment unless they're a legal spouse. So family members can take over the lease if they've lived together for at least 2 years and the person is a child, parent, grandchild, grandparent, sibling, or something we call a non-traditionally family member. This is someone who lives as if they're a blood relative. They act as if they're a blood relative in every way except for the fact that they are not actually. It's something that can be proven through church records, Christmas cards, shared bank accounts. It's hard to do, but definitely can be done. And so if you have a senior who's living with a child who might not be their grandchild, but they're raising them, this would qualify. A parent, someone raising someone else as a parent, or you have a senior who's living with a significant other who's not legally married, they will qualify for succession rights. It's important that people act immediately. Often people will wait several years before putting in succession rights, and they've missed that 2-year window. It's also important that people never put in a check for someone who is dead or not living in the apartment. Sometimes a child has control of their parent's bank account. They'll sign a check for their parent long after they've left the apartment. If they do this, they're committing fraud and will lose their succession rights. Landlords are able to get something called major capital improvements. This is one of the ways that landlords raise the rent. If they're on SCRIE or DRE, they will not feel these rent increases. There's a lot of ways of fighting them, particularly if the person is the last rent stabilized tenant in the building. They will not get these rent increases. If there's violations in the building, they will also not get these rent increases. There's a lot we're still waiting from the state to decide on how this program is being changed. If someone gets an MCI notice in the mail, please contact us or another housing group because we're able to help you fight it. The rent increases can be as much as 2%. The amounts people are paying are much less than they were thanks to the new law. But still, it's a lot of rent increases for a lot of people, and so it's important. Contact someone if you get an MCI notice, and if your client gets an MCI notice, If they're getting a notice about rent increases, please contact someone. So some other types of housing. So Section 8 vouchers. It's illegal for landlords to discriminate against someone with a voucher. They can't say no programs. Rent is generally capped at 30% of the family's income. It's really important that we report all income changes. There are no new vouchers in New York. So if somebody loses their voucher, it's a problem. There are vouchers from the city through the mayor's program to get families out of shelter, but Section 8 vouchers are closed. Section 8 buildings are when the vouchers for the building, not for the tenant. And again, it's kept at 30% of the family's income. NYCHA, which is New York City's public housing. Again, rent is capped at 30% of the family's income. It's really important. Again, people report who's living in the household. Even if the child who's sleeping on the couch they think is relatively temporary, the child will not get succession rights if their income is not reported and not on the family composition chart. And the person can lose their apartment over it. Tenants cannot call 311 to get a HPD inspector for their building, but they can report that when there's housing code violations. If someone lives in an unregulated housing, that might mean that they live in a smaller home, their roommate, or in a building that's newer. Landlords are able to charge as much as they want for the apartment, can ask the tenant at the end of their lease to leave for any reason that's not discriminatory or no reason at all, and a tenant may not or may have a lease. There are new rules around lease renewals or rent increases that are more than 5% for unregulated tenants. Tenants who live in an apartment for 1 year can get a 30-day notice. Tenants that live in a building for more than a year but less than 2 years can get a 60-day notice. Or tenants that live in an apartment for more than 2 years can get a 90-day notice. This will start in mid-October. So it's really important if someone gets a notice being told next month your rent increases, your rent's going up, or you have to leave your apartment. That is not the correct notice. There's a specific amount of days, and the notice needs to be mailed to them. And so that is it for my slides. So now I'll take any questions.
So it looks like we have two questions, one from Conrad and then one from Jose. So Conrad put his question into the Q&A section here. Are you able to see that, Andrea?
Yes,
okay.
I just figured that out. Okay. So Conrad says, I have rent concession on my current lease. On my lease shows a market rate lower than the rent I pay. The current lease ends December 31st. And my building received a notice in June that the landlord to sign a new lease because of, hold on, things are getting cut off halfway through. There we go. In June, from the landlord to sign a new lease because of a restructured design to keep the development affordable. The notice says if you have a subsidy, you will continue to pay 30% of your adjusted income. Any modifications to market rate adjustments, subsidy portion? No, there were no changes to the when somebody receives a subsidy. I do not think that you have a market rate apartment though. It sounds like either your building is an affordable housing program, so either the building has a Section 8 voucher or is covered under a tax abatement, which means you should probably get your rent history if it's not a Section 8 building, and you have what's called preferential rent, which is the rent concession that we talked about earlier. It's really important your rent can only go up by the Rent Guidelines Board if this is the case. in the past, your rent could go up, but in the future, your rent can only go up by the Rent Guidelines Board. Oh, there's more. So I went,
Did you see the second part?
yes. So I saw they were trying to raise my rent to the market rate, and the dates on the lease were backdated. Right. Do not sign a lease that's backdated. Get a current lease. Always get a current lease. Tell them you want a lease. I see you don't have a subsidy, but something in the building is subsidized in some way. So please get your rent history to find out exactly what's going on in your building and how much your rent should actually be. I refuse to sign the new lease and receive this recertification letter. So something, again, is happening in your building. Whether it's the building has a subsidy now, a tax abatement, it's entering a new program that they're asking you for this. You can be evicted for not giving this paperwork over, even though you don't have a subsidy. So it's important to figure out what's going on with your building. And then we have Jose's question. A NYCHA resident wanting to get a Section 8 housing, but stays in the same building. Different options in different boroughs are presented on in the portal. So for those who want to stay, do we abandon Section 8 altogether? So I'm a little unclear about this question. So it's a NYCHA resident who wants to move to a Section 8 building, and they're being given options.
Jose, can you maybe rephrase the question that you're asking, or just that second part for, I'm wondering if you're meaning, should they abandon applying for Section 8 altogether?
So just for both NYCHA and Section 8, the waiting lists are somewhere up to 10 years. So unless you have a medical reason that someone's getting a transfer inside of a complex, or they have a portable voucher, it's really hard to get a transfer. You should, not that you shouldn't try, but you shouldn't pin all the tenants' hopes to that transfer. And you want to make sure that if they're leaving, they're going to, they either have a portable voucher or they're going to a Section 8 building, because otherwise they will lose their affordable apartment. And that's the same true for if you live in a Section 8 building, it's not a portable voucher. It's only for the building. And so the person's options are limited if they want to stay in an affordable apartment.
Jose, I enabled for...
yeah, basically,
yeah, go ahead.
what I'm saying, oh, it's an echo. That sounds very Wizard of Ozzy.
You know, I'm going to take off my...
Yeah, that's okay.
Take off my audio. I think it's fine.
I like that echo. No, it's because when I went into certain individuals' NYCHA portals, they were eligible for Section 8, but they want to stay at Morrisania air rights. But I'm presented with options for them to choose different buildings other than Morrisania air rights, but they want to stay at Morrisania air rights. So what do I do with those individuals? Do I tell them that?
Why are they being asked to leave?
I'm sorry?
Are they being asked to leave their apartment?
No, they're just, I guess they've been given Section 8, or they're part of the Section 8 voucher program.
If they're happy where they are, they can stay, unless there's a reason they're being asked to leave.
Yeah, they're not being asked to leave. That's the interesting thing. They're just presented with different options to pick, and most of them don't. Actually, all of them don't want to move from where they currently are.
Then they can stay. I don't know why the system's showing that they have other options.
Because a lot of them are in like different boroughs and things like that. You know, things they're not used to. It's very odd.
Yeah, that is odd. And it's really important when with a senior to like that. If they want to stay in their apartment, they should, especially stay in that same neighborhood. And just because they're giving another option doesn't mean they should take it. If they have an affordable apartment in the place that they want to stay, they should stay there.
Yeah, that's kind of where I was leading, but I just wanted to get some clarification of that. Awesome. Thank you.
And for Jessica's question, the Section 8 program in New York City is closed. We do not expect it to ever open again, to be honest. There are vouchers from the city and state for people leaving the shelter programs, something called FEPS and SEPS, as well as City Link. And so if you have someone who's leaving the shelter, they can get a voucher. But if you just want someone to apply for Section 8, they cannot get a voucher. And if someone loses their voucher, they will not get it again. However, people can get a voucher if they live outside of New York City and then move to New York City and use their voucher. Any other questions?
Yanellis, I wanted to see if you had a question because your hand was raised. Kelly, do you have a question? I enabled you to talk. Okay, I have a question.
Okay.
So when we talk about the zip codes that are being phased in for having representation within housing court, I'm wondering, Andrea, if you know of the timeline or how they're phasing in the other zip codes, because I've had some people in housing court who were in a zip code in the Bronx, such as 10458. And so that's not one of the ones that has been approved yet. And I know that the city was looking to do that for, eventually all zip codes. Is there any indication for that?
So there is not right now. There is a bit of a shortage of housing lawyers for the program, which is why the phase in has sort of been stuck at 5 zip codes for a little bit. But they do say that all zip codes will be phased in by 2022.
2022 is the
goal date.
The year by which all zip codes? Okay. Well, that's a goal, I guess.
But if you have a senior or somebody who's low income, they still may be able to get a lawyer. It just requires a lot of advocacy on our part.
Okay. And I had one other question for somebody who is being overcharged right now for a new lease for their apartment. It's a little bit similar to Conrad's, where the landlord is trying to have them sign a backdated rent from June 1st, and the older adult was basically signing the lease on August 8th of this year. And so if they're going to be filing this overcharge with the DHCR, it looked like you said they would be filling out the RA 89 form. Is that something that usually is resolved by the DHCR without having to go to housing court?
Yes. So anything that you file with DHCR, you actually can't go to housing court over. You have to choose which one you want. And it does take a long time. It can take up to a year to get DHCR to respond to an overcharge complaint, but they will do it, and you do not need a lawyer. It's part of going through that HCR program is that you don't need a lawyer. It's pretty easy to fill out on your own.
Okay.
And people should not feel pressured into signing a backdated lease. If they're in a regulated apartment, they can file also with the state to say they want a proper lease and wait till they get the proper lease, rather than being concerned that they may be either being overcharged or even worse, that the landlord's then going to claim that they owe the rent increase.
Could you just repeat that part where you said that they can file for having been pressured to sign a backdated lease? What would they be doing in that instance?
Sure. So if you do not get a proper lease to rent regulated apartment, so that means that the amounts on the lease are wrong, that the dates are wrong,
Mm-hmm.
or you just simply don't get a lease, you can file with DHCR. And the form is called failure to renew rent stabilized lease. And DHCR will then yell at the landlord and say you need to give someone a proper lease. Until they give you the proper lease, the old lease is in effect.
Okay. Because the situation that I'm talking about with this older adult is for a rent stabilized unit. However, they were, you know, it was sort of a sublease when the person who was the lessee had left the apartment. And so there was not, you know, a lease from which to go back to, because they were, you know, sort of presenting him with this new lease for him to be the primary tenant. It's called failure to review.
Renew a rent stabilized lease. So if the person that's their first lease, they will not be able to fill out the form.
Okay. It would have to be done by the previous.
Well, it's not a renewal lease in this case. It's a new lease for this person.
Yes.
But if they're being overcharged, they can still claim they're being overcharged.
Okay. So then go with the RA 89 form.
Yes.
Okay. Thank you.
And I see there's another question about having both a Section 8 voucher and NYCHA. You might want to look to see if there's something happening at that NYCHA complex that people are getting now put onto the Section 8 program. Either the buildings there's being infill, they're trying to build market rate apartments in some of the extra land they have, the building's being converted to something else. You all might want to look into what's happening if it's the same complex to see if something weird's happening to that building.
Mm-hmm. I think Yanellis is at a different building than Jose. So there's a senior center within 950 Union Avenue where Yanellis is, and then as Jose was saying, his center is in the Morrisania Air Rights building. But do you mean are you referring to the management office within, you know, those buildings?
It might be that in the management office, or it might be the city and state are doing. There's lots of things that are happening to NYCHA right now, where they're talking basically about privatization, and some of that will put people on Section 8 vouchers or make a building Section 8. They're talking about moving in market rate tenants to certain parts of buildings. This is really bad for NYCHA. NYCHA is not doing great under public overcharge. It's also not good. It's going to be done even worse in private hands. The problem with NYCHA is that New York City and New York State do not care about poor people. That's why NYCHA is not being cared for. That's why it's not being repaired. It does not have anything to do with the state or city looking over it versus private hands. In private hands, people will be forced out of apartments so that market rate tenants can be moved in and they can make more money. It's really important that we preserve the housing that we have in New York City because we're not getting new housing. The federal government does not allow New York City to get new Section 8 vouchers or to build new public housing. So if we lose what we have, we will not get any more, and New York City is not getting any less expensive. So if you're seeing something odd starting in a NYCHA building or a Section 8 complex, please look into it. Ask some questions of why it's happening.
That's a good recommendation. And I know that the Metropolitan Council on Housing is, you know, a group at the forefront for trying to preserve what is the affordable housing now of, you know, not being lost forever. Okay, so I want to give everybody one last chance to ask a question. Either type it into the Q&A now or raise your hand. If there aren't any other questions, then we're going to wrap it up and conclude this webinar. Any hands going once, twice. Okay. There's one last thing that I want to just show everyone, which is okay. So I want to thank Andrea Shapiro of the Metropolitan Council on Housing for giving that presentation such vital information to residents, especially older adults of New York. This is right before you now is the the websites for the various organizations and programs that we have in PSS. So once again, thank you, Andrea, for being with us today and answering our questions.
Thank you.
Okay, and I did have somebody who had texted a question. Is it possible for you to share the PowerPoint?
Yes. I
Okay.
can share it with you, then you can share it with folks.
Wonderful. And I know that there were one or two people who weren't able to attend, so I know that they would appreciate that too. Thank you so much for your time, Andrea, and thank you everyone for attending this webinar.
Thank you. Bye.
Bye, everyone.